Drafting is writing patent applications, so turning the information that you get from a client into a legal document that describes and protects their invention. Prosecution is, once you file that patent application with the patent office, is about essentially arguing with a patent examiner about whether or not you're allowed to have a patent. So the patent examiner usually comes back and says, no, I don't think this invention is new, or I think it's an obvious thing to do, and you've got to put together the arguments that will get your client the patent, and that's patent prosecution, so the process of getting patents. Opposition is the process of when you've had a patent granted, that a competitor of your client can file an opposition to say to the patent office that they don't think that patent should have been granted, and they can present the reasons why, and the patent office will take another look and decide whether or not they agree with that case. That's one of a particularly interesting part of the job, because you find that in situations where a company's patents are being imposed, they're probably more commercially significant than perhaps other patents that fewer competitors are worried about. And you've also got someone to argue with there, because you've got the other side in there, so that's a particularly good part of the job. Appeals would be the second line of legal recourse if your request for a patent application were to be rejected. So if the patent office says no, we don't think you can have a patent for that, then you may be able to file an appeal and ask a further body, so an appeal board or some such thing, whether they agree with the decision of the examining division. You can also file appeals against opposition decisions as well, and appeals again tend to be quite an interesting part of the job, because if it's worth filing an appeal, it's probably quite an important case, and there's probably quite a difficult legal issue to deal with.